Good evening to you from New York. I am Ari Melber, filling in for Chris Hayes, and tonight there is breaking news in the federal investigation into the lane closures on the George Washington Bridge at the center of the so-called Bridgegate scandal surrounding New Jersey Governor Christie. We can report tonight for the first time that the attorney for Christie's press secretary is confirming this evening that his client, Michael Druniak, testified today before a federal grand jury at Newark, New Jersey's federal courthouse. In addition, both ABC News and the New Jersey Star-Ledger are reporting that a grand jury, quote, is now hearing testimony in the federal criminal probe into the George Washington Bridge scandal. Druniak's lawyer confirmed to ABC News that his client was, in fact, a witness today, and only a witness. The attorney emphasizing that, quote, I'm not going to get into the specifics as to what would be discussed in the grand jury. I would say, though, that Mike is a witness, and we have been assured that he continues to be a witness throughout these proceedings. ABC News reports that 23 jurors were impaneled at that federal courthouse in Newark today as part of this federal investigation led by U.S. Attorney Paul Fishman. Now, the investigation has been looking into whether or not Christie or his aides may have violated federal law last year, and Michael Druniak has already met, this is important, he has met with federal prosecutors before. In fact, his lawyer told Bloomberg last February that he, quote, met prosecutors working for U.S. Attorney Paul Fishman in Newark, New Jersey. So what's different now, what we're reporting tonight, is this new testimony, and that's testimony that could indicate that prosecutors are gathering new or additional kinds of information pursuant to this formal investigation. It could also mean the jury will hear from additional witnesses. Indeed, it is not usual to only hear from one in an investigation like this. Now, who is Druniak? Well, he is a close aide and trusted ally of Governor Christie. He was his longtime press secretary, and interestingly, he previously worked for him at the U.S. Attorney's Office. Of course, that's the very U.S. Attorney's Office where this federal investigation is proceeding. The reason his testimony today is so potentially significant is because, remember, a grand jury is a pretty serious federal proceeding. Witnesses must testify without a lawyer, and they cannot plead the Fifth in that setting. We could see many more developments growing out of today's news. Joining us to help unpack it is former federal prosecutor and current criminal defense attorney Bradley Simon, Paul Butler, professor of law at Georgetown University Law Center and a former federal prosecutor with the U.S. Department of Justice, specializing in public corruption, and criminal defense attorney Brian Weiss. Welcome to all of you. Bradley, let's start with your experience in these kind of offices as a federal prosecutor. What does it mean when we see a witness go in and speak to a grand jury in a case like this, an inquiry that thus far has not had confirmed evidence, confirmed reports of folks going in for this kind of testimony?
Well, the fact that a grand jury has been impaneled means that the investigation has risen to a new level. Grand juries are secret proceedings. They consist of individual jurors between 16 and 23 in number. And the entire process is controlled by the government. Defense lawyers are not allowed into the grand jury room. And it is, in a sense, a one-sided proceeding. Our former chief judge in New York once said that a grand jury could indict a ham sandwich.
Right.
So if, in fact, the U.S. attorney decides at some point to present charges, it is more than likely that the grand jury will return what they call a true bill and indict.
Right, and a true bill and indict. Let me go to Paul, who also has this relevant federal experience, which is why we want to talk to you. You've also kept an eye on this case, and this is a witness here who has both been very loyal to Governor Christie for a long time, who also, as I mentioned, knows this office, worked in this very U.S. Attorney's Office, and whose lawyer says he is there strictly as a witness. So, Paul, what's your interpretation of what we're learning tonight?
I think that what the U.S. Attorney is doing is trying to lock in testimony. So they'll come in, they already know what he said because they've interviewed him. Right. So they're going to get him to put it under oath on the record, and that way he can't change his story. And that's what you do when you're trying to make a case against someone. So, you know, before this point, if I were Governor Christie, I wasn't quaking in my boots. I'm still not quaking in my boots because grand juries investigate lots of people who they don't indict. But I'm very worried because this is all about the prosecutor's call now. That grand jury is going to do whatever the prosecutor wants.
Brian, let me bring you in, particularly as a criminal defense attorney. Any reaction to what you've heard? And again, speak to the situation that anyone would find themselves in if they go before a grand jury and they'd rather not testify.
Yeah, make no mistake, this investigation has now reached DEFCON 1. I have said all along on MSNBC that the legislative investigation that's been undertaken by the Jersey legislators was spring training, AAA. Now they have reached a critical mass. And what's important, what your viewers need to recognize, basically two things. Number one, this grand jury is not going to pass upon the guilt or innocence of anybody who they may have in their gun sight. Only probable cause. Is it more likely than not that these folks have violated federal law? And Bradley makes a great point. This is a totally one-sided proceeding. The closest defense attorneys get to this proceeding is in the hallway or maybe the green room if they even have one. But right now, Paul Fishman is about to begin a phase of this investigation that, as we've said all along, guys, will change some careers and others and turn people's lives upside down.
So, Brian, let me drill down on the point you raised there, make sure we're understanding it correctly. You're referring in part to the standard of proof that would be required here, but you're also making a suggestion that the fact that they're taking this testimony means some people will be indicted, or at least that's more probable than we previously thought. To be clear, though, that's not at all guaranteed by the fact that they're collecting testimony, correct?
Absolutely, you are absolutely right, Ari. Look, that the standard of proof, again, not guilt beyond a reasonable doubt, and like we've heard, grand juries are impaneled all the time who ultimately investigate and then decide at the end of the day that there's been no violation of federal law.
Bradley, let me go back to you then. So you have that possibility that they will use this process, hear from these witnesses, and not indict anyone. What do you think, in your experience, though, is the kind of goals at this point when you have a federal investigation of this kind? Because as you mentioned, they didn't need to go this far. They clearly feel that having looked into this, they want to take more testimony, including, as Paul Butler referenced, testimony that is in some sense redundant or explores upon what they've already heard from this very gentleman.
Right. They're going to want to try to make out a case to make sure that they can satisfy the elements of various federal statutes. There are many statutes, mail fraud, wire fraud, that are in the government's arsenal that are very broad, that if the government wants to use those statutes, they can, and they will be likely to be able to make a case. And they also have a wide range of latitude. They could be looking at the allegations made in Hoboken by the mayor as well. That might fall under the mail and wire fraud statutes. So, you know, they have a lot of latitude of where they can go. And the fact that it's gone to this level in such a high-profile matter suggests to me it's not likely to just go away. You know, if he wanted to look, if Paul Fishman wanted to look at this matter quietly and then take no further action, he could have done that. The fact that a grand jury is being convened in such a closely watched case suggests to me that this isn't going away.
Right, and let me bring in Paul. I mean, that is significant. Again, if anyone's just joining us here, the breaking news tonight being that we have confirmation from a lawyer for a former top aide to Christie who testified today before a grand jury, the first such confirmation of that kind. And so, Paul, as we try to understand that, what do you make, though, of the lawyer's claim here, which we've been reporting, that Druniak here is not anything other than a witness? Can a lawyer even responsibly make that statement unless he's received some assurance from prosecutors, in your view?
So what you do when you're representing someone who gets subpoenaed to come before the grand jury is ask, is my client a target? Which means, is he someone who you are thinking about thinking about bringing a criminal case against? And if the answer is no, then you usually let your client in if you don't think he has any exposure. Now, people can actually claim Fifth Amendment. The Fifth Amendment still applies to the grand jury, which is why they're not likely to invite principals like Mr. Sampson or Governor Christie to come in. You know, the big get would be Bridget Kelly, but she would only testify if she gets immunity or if she works out some kind of deal.
Brian, can you speak to that and how that wrangling works? Because we've heard a lot about different potential witnesses who are very publicly stating they want immunity before they speak.
Sure, I think that there are two kinds of people who are ultimately going to testify in front of this grand jury: witnesses and then targets. And I think Paul and Bradley will underscore the fact that when you as a criminal defense attorney get a target letter from the assistant U.S. attorney who's in charge of the grand jury investigation, you know that you don't want to walk in there without immunity, because target means exactly what it says, that you are within their sight as somebody who is likely going to be the subject of whether or not you violated any kind of federal law. And one thing, Bradley pointed out all of the various offenses that Paul Fishman can bring to bear. One that I really think your viewers need to understand is conspiracy, the darling of the prosecutor's nursery, where Jack McCoy on Law & Order used to say is great because the right hand didn't know, or have to know, what the left hand was doing.
Yeah, let me go to you then, Bradley. Speak to that, and if you're not a target, how much can be compelled out of you in these proceedings?
Well, if you're not a target and you're told that by the prosecutor, then you have to go in and testify. And so I think if the lawyer said that he was not a target, then he pretty much has gotten assurances from the U.S. Attorney's Office that his client is not. But
and let's pause right there, just on that point. If he has those assurances, does that suggest to you, can we interpret anything out of that about the state of the investigation? If Mr. Fishman in this investigation has determined that someone who was a top aide, who I should mention was in some of these emails back and forth about the traffic, they've at least been able to determine, in your view, based on what we know publicly, that he's probably not a target. Does that mean they're pretty far along?
Well, I think that's how they make these cases. They bring in witnesses who have firsthand knowledge of the offense, and they want somebody a little lower down the chain.
One second, then I'll go to you, Paul.
You know, and they work their way up. So, you know, he being the press secretary, he's in a good position to have relevant information for the grand jury. So, you know, that's the standard way how the prosecutors make these cases. They work their way up.
Right, and how they build their way up,
Right.
which in that we've mentioned Law & Order before is not unlike some of what we see in the popular examples. Paul, please go ahead.
Yeah, I was just going to make that point. That they're what's called pyramid investigations. So they start at the bottom. This is a relatively low-level witness. He has no exposure, but what they're doing is working their way up to the top. You know, we got a signal a couple of weeks ago when there was this turf battle between the U.S. Attorney in New York and the U.S. Attorney in New Jersey about who was going to investigate Sampson and the potential conflicts of interest at the Port Authority. And the U.S. Attorney in New Jersey seemed to make a power play to get that part of the case. So that suggests that they're taking this very seriously.
Yeah, that's a great point, Bradley. Briefly on that, Paul Butler's referring to the fact that Parit here in New York had stepped up and actually issued some calls for documents, then walked it back. That's fairly unusual, particularly as we know in what is a high-profile, potentially political case. What did you make of that for our viewers who may not have heard about it?
Well, that's not so unusual. There are turf battles going on all the time between various U.S. attorneys' offices. You know, the Eastern District of New York, Southern District of New York, New Jersey, they fight all the time for cases.
But do they, publicly, where they put out a call for testimony like that?
Well, it's, you know, obviously, I guess Paul Fishman won the battle, but yeah, you see that happen quite a bit. While they work together in some respects, they're also competitors. So.
And let me just go briefly, Brian, before we go, your final thoughts on what we might expect here and if there are going to be other witnesses coming before this grand jury.
Yeah, I think traditionally, at least here in Texas, federal grand juries sit for 6-month terms. And that's a very long time and will give the prosecutors and investigators and case agents a chance, as we've heard from both Paul and Bradley, to build this case from the ground up. Look, Ari, this is no different than an organized crime case from 20 years ago. You don't show Jaws in the first reel. You want to make sure that you bring in the foot soldiers, the people who are witnesses, before you get around to the targets. And over the course of the next 6 months, we are going to see people's lives changed in a very dramatic way, guys.
Thank you, Brian Weiss. Thank you to Paul Butler and Bradley Simon, former federal prosecutors, for your insights on a fast-breaking story here. We're going to keep an eye on it tonight. Coming up,